Hello, everybody. This is Frank with Iron Age News on the South Florida Conservative News Center. It is Thursday, October 30th, 12:30 in the afternoon. Beautiful day, getting ready for hurricanes. And while we're talking about that, those of you who have seen, we've been posting things from a couple different sites. A lot of the real war this week is not sending the troops to Chicago or Detroit or Los Angeles. It's what is going to occur in the Supreme Court in a variety of different cases. We touched on one earlier. I have another one, once again, about the Jean Carroll farcical rape story. Can we say that word? Well, we're going to say it anyway because YouTube is not our friend. And this one, which is the Doe's Horchul case. And I will explain it and then where it goes and what we know has occurred since then to make this probably the best case for the citizens of the United States who were victims of a pretty tyrannical governmental system at the time and should have been better treated than they were. But let's just go forward with this. And we're going to dive into this. This is one of the most important and least understood cases to come out of the COVID era. It's a case that began quietly in New York, unfortunately, but it might become the test that decides whether government officials, health agencies, and even private employers can be held accountable for what happened during the pandemic. All right. This is Does 1 and 2, Does, I'm saying it again. Does 1 and 2 versus Horchul. And it's not just about the vaccines. It's about what happens when truth itself becomes a casualty of a public health policy, especially one pushed by an organization that is a government into and of itself. And obviously the setbacks that occurred when elected officials believe the organizations that are supposed to work for them. So let's rewind to 2021, shall we? New York State has passed a rule, 10 NYCRR section 2.61. All this will be on the southfloridaconservative.com in text form for you who need to know all the real information and the graphs, etc. And this required all healthcare workers in hospitals and nursing homes to get the COVID vaccine. If you did not have the shot, you were not allowed to work. The rules allowed medical exemptions, but not religious ones, because a number of religions, the Muslims especially, born-again Christians and such, could get around it. If you had a heart condition, you could stay home and work from there. If you had a religious objection because the vaccines were connected to fetal cell lines or something, too bad. You had to take it anyway. A group of healthcare workers, all using pseudonyms like Jane Doe, John Doe, etc., sued the governor, Kathy Hochul, and their former employees. They said their firings violated Title VII of the Civil Rights Act, which requires employers to accommodate sincerely held religious beliefs unless doing so creates an undue hardship. That was the important part of this, undue hardship. They also said the state rule violated the First Amendment's free exercise clause because it treated religion as less worthy of protection than medical concerns, which it did. Lower courts sided with the state. It's New York. Judges said the rule was neutral, generally applicable, and backed by science that said the vaccines were safe, effective, and necessary to protect patients. Case closed, or so everybody thought at the moment as the steel curtain started to drop on America. Now, fast forward that to today. Now, we have had a series of FOIA requests, whistleblowers, congressional investigations, especially during the Biden administration, and the story looks very different. Internal CDC and FDA emails show that as early as mid-2021, health officials knew the vaccines did not stop transmission. In other words, a vaccinated nurse could spread COVID just as easily as an unvaccinated one. At the same time, manufacturers like Pfizer and Moderna were documenting elevated rates of myocarditis, neurological issues, and menstrual disruptions. But these risks weren't disclosed publicly for months, And as we know, they were later able to dupe the government into signing a document making them held harmless for any of these issues, right? Yet state mandates kept citing the same line. We must vaccinate healthcare workers to protect patients. That's the justification that carried Doe's versus Horchul through the courts. But if that premise was false, or worse, knowingly false, which we are seeing, the entire legal foundation for the Horchul defense collapses. And here's why that matters. Under Title VII, employers can only deny religious accommodations if granting them would cause an undue hardship. Hospitals argued that letting unvaccinated staff work was too dangerous. Why? Everybody's able to transmit it, right? Is what we're seeing. Everybody could transmit COVID, even if they were vaccinated. And they knew it at the time. But if vaccination didn't actually stop the virus from spreading, there is no hardship. It disappears, right? The state's rule and every firing that followed was based on misinformation. We're not even going to talk about the situation where they left old people to die in a nursing home. That is beyond this, but is attached to this as well. In plain language, people lost their livelihoods, probably banned from the organizations they worked for, over a lie. And that's not just an employment issue, it's a civil rights issue. If government officials knew the science didn't support their mandate, then enforced it anyway, that's a violation of the First Amendment, which we now know is true. If they coerced private employers to do it, that's a potential Section 1983 claim for deprivation of rights under the color of law, which we also know is probably true. And if manufacturers withheld data that propped up the whole mandate system, that opens the door to fraud and misrepresentation suits, possibly, and this is the killer, possibly piercing the federal immunity normally granted under the PrEP Act. The whole point of these guys releasing this poison was they would never get in trouble for it if something went wrong. However, we are starting to get more and more information that shows that they did know all these things, that they still continued to do it, and they did it in order to enrich themselves, to allow themselves to be held harmless, and God knows what the other reasons were. We still haven't gotten a real story out of Anthony Fauci, but what are we going to do, right? And where does this go from here? The Supreme Court is scheduled to consider this case petition in early November. If they take it up, this could be the case that finally tests whether state mandates can override federal civil rights law, and whether deference to public health expertise still holds when that expertise turns out to be politically manufactured. Because we are pretty sure we will see something like this again when the Democrats are back in charge. Let's not follow the red herring that Trump was in at the time. Trump was lied to. Trump thought these people worked for him and with him, and his own level of arrogance, we'll have to say that, did not let him see these guys as being the backstabbing sociopaths that they were. The man has to take responsibility for certain things, but who would have anticipated this, right? Would you have anticipated this? I know I didn't, but here we are today, right? Meanwhile, attorneys for terminated workers are preparing a Rule 60B motion. That means they are going to ask to reopen the case because they have new evidence that changes the entire story. And they have the CDC memos, they have manufacturer safety reports, they have congressional transcripts that didn't exist when the first rulings came down. If those files go forward, filings, you should expect to see new Title VII suits against hospital and state agencies. And this is for all you people out there as well that were involved in this. Find out if you're available to go into a class action suit. Let's not waste your time and everything else that happened to you people. It was a goddamn shame, and let's get some restitution for you. So we're probably seeing new Title VII suits against hospitals and state agencies, civil rights complaints under Section 1983, as I said, for religious discrimination, and even fraud claims aimed at officials who enforced a mandate that they knew was factually unsound. But the implications don't stop with a handful of New York nurses. If the courts acknowledge that these mandates were enforced under false pretenses, which we are seeing a huge amount of information that they were, it calls into question every emergency power exercised during the pandemic. The lockdown orders, the church closures, the travel bans, the detentions under quarantine authority. Each of these actions limited constitutional freedoms based on scientific claims we now know were at best overstated and at worst deliberately misleading. To what end is not for us to question at this point. And that raises the big haunting question. If government can suspend rights using bad data once, what's to stop it from doing so again, which is what we said. And who is the best person at it? The people that are right now trying to engineer another civil war for November 1st. There's a phrase lawyers use that says fraud vitiates everything. It means that if a policy was built upon deception, that deception infects the entire system. That's where Doe's versus Horchul is headed. What began as a fight for religious liberty may soon become a referendum on government honesty during the COVID era. So for the fired healthcare workers, it's going to be about restitution. For the rest of us, it's about making sure the next emergency doesn't come with the same quiet suspension of rights, the same intimidation, and the same censorship of dissent. And I will tell you, for personal experience, even here in South Florida, where they said we did not have all that bullshit, they are fucking liars. We had lockdown at the beginning, just like everybody else. In fact, a number of the towns right around here, and I'll name Deerfield Beach for one, love to go out there and bust balls on this whole thing and issue tickets. I think if you looked it up, they were going to hire more people to go out and harass people for trying to make a buck. The amount of businesses that went out of business in South Florida during COVID or because of COVID is astounding. I don't think we've actually come back from it correctly. And here we find out it's all been a bunch of crap, right? So the pandemic has forced the Americans to ask how much freedom they are willing to trade for safety, right? But those Horchul asked the opposite question. How much deception, how many lies are we willing to tolerate in the name of science? As truth comes out through FOIA requests, whistleblowers, courtroom battles, et cetera, one thing is certain. The public health establishment will never again be able to claim unquestioned authority. And that may be the first step toward rebuilding trust and justice in the aftermath of the lockdown years. So if you found this episode useful, share, subscribe, stay tuned. We are on YouTube, Rumble, BitChute, Substack, and our own Sleestack, and our own SouthFloridaConservative.com. Any ideas for other articles you'd like us to take a look at for you? We are more than happy to do so. And that is about that. And have a good Halloween. Goodbye.